Legal insights for IV therapy businesses. Hello, I'm David Holt. I'm a healthcare attorney at Holt Law, the law firm built for healthcare businesses like IV hydration businesses. Today, we're addressing some of the legal perils associated with IV hydration therapy and outline potential legal strategies and solutions. We assist healthcare businesses like yours in navigating the complex regulatory landscape of health and wellness, and we're well versed in the challenges you face when launching or scaling a new health and wellness service or business. Now, picture this situation. You're a healthcare entrepreneur and a licensed MD. We'll call her Dr. Sarah, who works part time at a wellness clinic, is a personal acquaintance. You propose hiring Dr. Sarah as a 1099 independent contractor to deliver mobile IV hydration therapy. She's immediately interested. However, you're concerned about the potential legal pitfalls. What steps do you take? What guidance do you offer Dr. Sarah? This is a pretty common scenario with numerous variations that we see frequently with our healthcare clients, particularly those startups venturing into mobile IV hydration and other IV related services. These therapies are in high demand, even beyond the pandemic context, as some IV formulations are believed to enhance immune function. Mind you, I'm not endorsing or promoting these therapies. I'm simply addressing the legal issues that our clients raise when they want to provide IV hydration therapy. I'm not an academic. I'm speaking to you about the healthcare entrepreneurial space and the legal issues you might encounter and how to anticipate regulatory perils or potential litigation. Now, there are in fact multiple legal and regulatory challenges. First, the fundamental question, who is prescribing the IV? Is it you, the clinician? Is it simply an order? And does it make a difference? Remember, prescription is a legal term. Furnish and administer are all distinct terms, and there are questions about whether the clinician needs to be licensed in the specific state or if licensure elsewhere is sufficient. Second, who's the clinician? Could it be a registered nurse? Could it be a paramedic? What about an EMT? What would be their scope of practice? Would that require supervision? What about Dr. Sarah? What about the corporate practice of medicine? What about lines of supervision and liability? What's the appropriate business structure? Would it be a corporation, an LLC, a professional corporation? Who is within the corporate structure? Also, can you be paid by a percentage, like of the IV units delivered, or would this raise anti-kickback, fee splitting, or even Stark Law violations? And fifth, does the composition of the IV cocktail matter? Does the cocktail need to be FDA approved? Who's authorized to transport it? Are there state licensing agency regulations that could come into play? We dive very deeply into these issues and many more. Some of them we cover in various blog posts on our website. We have posts about independent contractor issues, physician compensation, kickback concerns, corporate practice of medicine doctrine. We even also address FDA regulation of IVs, regulation of other substances, the business structures, and whether a professional corporation or a PLLC would make good sense. Also, there may be the thing called a management services organization that comes into play too. If you're interested in an early and more in-depth look beyond our blog and this video, I think you'd probably benefit from a legal strategy session with a member of our legal team, and it's an excellent way to get started in this highly regulated field. For more valuable healthcare law insights, feel free to jump onto our website at djholtlaw.com. Thanks for your time.